Welcome to another episode of Tort Talk Thursday. As always, every week, Joe, happy for you to take time to connect with me and the industry and give us the latest and greatest updates on mass tort.
Thanks for having me, Susan. I always love speaking with you. A lot going on this week in mass tort, so really excited to get into it.
Yeah, great. Hey, right before we dive into the updates, I just want to thank today's sponsor of Tort Talk Thursday, which is Shield Legal. Shield Legal provides the highest quality leads in the industry. And personally, having worked with them for so long, I can attest to the quality and their minimal fallout rates. I think one of the important values to me is that they approach every relationship with a true partnership mentality versus just another vendor in the space. So if you're looking for great leads and a new partner, I highly suggest and recommend reaching out to Shield Legal. With that said, Joe, why don't you start us off and talk a little bit about what you've heard as it relates to the barred settlement?
Yeah, Susan. So the one that we've all been waiting for here is the barred hernia mesh MDL settlement. We had a recent development. Two law firms actually filed a motion recently here to file under seal the qualified settlement to set up the QSF. So what that is, the document that's going to appoint who's going to be in charge of the money. And it also is going to have the MSA, the Master Settlement Agreement, in there. This settlement is not a global yet. It's going to involve only these two firms who I understand have a couple hundred cases. They don't have the hugest inventories, but it's a good sign for all of us. It's showing us that cases are being resolved. We heard a couple years ago, several thousand barred cases got settled outside of the MDL. So we're all going to be waiting and watching the docket over the next couple weeks to see if there's a similar filing by leadership establishing a QSF and then an MSA for all cases, which we're hoping is going to be the MDL and also Rhode Island. So stay tuned for that.
Great. Let's talk a little bit about Purdue. What are you hearing of this week? We all know the Supreme Court bankruptcy and the ruling. Why don't you share and provide a little update there?
Yeah, it's really rare that we have a mass tort case make it all the way up to the Supreme Court, but we just had that and the decision came down. So basically, as everybody knows, we had these opioid cases and one of the main defendants was Purdue and their owners were the slackers. So basically what was going on as part of the bankruptcy, there was a bankruptcy plan in place, but then the Biden administration objected to that. And basically they were saying that having a third party release the slackers who themselves were not filing for bankruptcy as part of the plan, that was improper. And in a surprising ruling, the conservative court in a 5-4 split made up of some conservatives and some liberal appointees ruled and said that the bankruptcy could not go forward. So basically what this means is that bankruptcy plan is blown up now. We're going to have to go back to the drawing board. It's going to take more time and more money now for the slackers to put in. And so that's a little bit disappointing for that. Overall, though, we're hoping this could have some positive developments in mass torts going forward, standing for the premise that the bankruptcy court is not to be used by non-bankrupt entities. We're looking at you, Johnson & Johnson, down the line here for this talc anticipated filing. How it plays out and whether there's a narrow reading, we'll see likely in the Boy Scouts coming up, or if there's going to be a broader reading, which we're hoping for, making it harder for companies to discharge some of their liabilities and move forward with some of these abuses of the bankruptcy system. So huge ruling. We'll see how the chips fall in the coming weeks.
So it sounds like, Joe, initially sounded disappointing, but really it's wait and see how, like you said, how the chips fall.
Yeah, it's disappointing a little bit for the people involved in this litigation and those people who need the money to help the opioid epidemic, but broader picture down the line, it could be good for all of us in this space.
Okay. And then lastly, let's touch base on any new developments with the Uber sex abuse cases.
Uber sex abuse cases are heating up. So we have them out in California in an MDL and in state court. As you know, Uber tried to get all of the cases dismissed. They're saying that their terms of agreement, which have a non-consolidation consent, prevented an MDL or the coordinated actions to be filed. We ended up winning on that. Now Uber is seeking interlocutory appeal of that. Meanwhile, all of that's going on. We're fighting that. But fortunately, the judges are pushing the cases forward. They're not delaying discovery. Things are moving forward. And it looks like this time next year in state court, we're going to have our first Uber trial. So instead of arguing about some of these procedural issues, we'll really get into some of the facts of the case, which are pretty horrific for Uber.
Right. Well, Joe, as always, grateful for your time. Thank you for spending a little bit of time talking about the updates and insights, and I hope you have a great day.
Thanks for having me, Susan.